Hammersmith.
Right. Lords and Milady, there are, of course, just two matters that arise on this appeal. The first has to do with the appellant's challenge to the findings of the courts below that the disputed lands fell within the Grenada estate, which had been conveyed to Samuel Corion in 1914, and that therefore the estate of Samuel Corion had proper paper title to the disputed lands. The second is the appellant's challenge to the findings of the court below that the appellant had failed to prove that the disputed lands were foreshore and that therefore the Crown was entitled to the benefit of the seabed and foreshore presumption in relation to the disputed lands. With respect to the first matter, while my learned friend sought, for good reason, to characterize this question as primarily one of construction in any practical, sensible sense, the problem which confronted the courts below was not primarily a matter of construction. As I think it was my Lord Briggs observed sensibly to my learned friend, one could stare at these conveyances till you were blue in the face, but it would do nothing to assist the courts below in resolving the real practical question that they had to answer for the parties. It is self-evident that the courts cannot resolve questions of where the relevant boundaries, and I underline with respect the words relevant, where the relevant boundaries of the Grenada estate were, and therefore whether the subject parcel, the disputed parcel, was within the boundaries of the Grenada estate conveyed to Samuel Corion by simply reading and construing the 1914 conveyance. The courts below had to have resort, of course, to the words of the 1914 conveyance, but also to whatever evidence there may be of the surrounding circumstances and to other extrinsic evidence that might be available, which could help answer the questions of where the relevant boundaries of the Grenada estate were in fact located, and whether the subject parcel was in fact within those boundaries. Towards the end of his submissions, my learned friend recognized this when he stated, and this I hope is an almost complete quotation, I noted it, the real question is what was the Grenada estate at the date of the 1914 conveyance? That is a question, as he had to accept, which required findings to be made from the evidence. The courts below made those findings. The appellants, of course, are dissatisfied with those findings and seek to challenge them. But we respectfully submit that there is no reason for the board to depart from its established practice of declining to go behind concurrent findings of fact by the courts below. Indeed, at paragraph 20 of our printed case, which is at page 750 in the electronic bundle, we give you for completeness.
Sorry, the paragraph again, please.
Paragraph 20 of our printed case, page 750. We just set out there, my lord. I'm not going to take you to it because it's more familiar to you, my lords and my lady, than it would be to me, the summary of the position in Das and Marchand. But we emphasize that the rationale is particularly applicable in a case such as this, where we're dealing with a land dispute in a tiny island of Carriacou, off the northern tip of Grenada, and where the local court, to answer the problem, had to have regard to its understanding of what kind of evidence would be available, what the practices in such a society would be as to how this would be approached in circumstances where the deeds had no plans and indeed no descriptions of the boundaries. How would one go about working out the answer to the question that my learned friend framed? What was the Grenada estate at the date of the 1914 conveyance? That is a question that, with the greatest of respects to my lords and my lady, is far more suitable to be answered by those in the court below in Grenada than it would be by this board. And that is why the second rationale provided for the practice in Dasamachan is of particular applicability in this case. We respectfully suggest there is no reason, and none has been suggested in our submission, why the board should depart. But in any event, even if the board is prepared exceptionally to go behind the concurrent findings of the court below, we respectfully submit that the evidence in this case supports their findings, and in particular supports their conclusion that the subject parcel was in fact part of the Grenada estate that was conveyed to Mr. Samuel Corion. And in this regard, if I can take you back, my lords, because I think this is a crucial document, to the 1904 plan of the Harvey estate that my learned friend very kindly provided you with a larger copy of, and I would use that larger copy here. Now, my lord, I'm not going to take you, because my learned friend has already, back to the 1885 conveyance or to the 1914 conveyance, because we know how little they say. Both of them basically say, we are selling you the Grenada estate. One describes it as comprising approximately 160 acres, more or less, or words to that effect. The other says, I'm sending you all that plantation known as the Grenada estate, comprising, again, some wood.
I thought you would place some significance on the fact that they're saying that they're selling all the land that was...
Exactly. That is correct. And in our printed case, we make that point. Both of them are conveying all of the Grenada estate. So that's the first idea that they give. That what each is conveying is all of the Grenada estate as it was at that time. So there's no issue, and the learned friend hasn't suggested that there was any reservation of any part of the Grenada estate when the estate was conveyed in 1914. So perhaps I was just trying to go too quickly. The lady is correct, and you're right about that. I should emphasize that point. That there is no doubt that what was being conveyed in each case was all of the Grenada estate, and there is no doubt in particular that in 1914 there was no reservation. And indeed, if you look at the 1914 conveyance to Samuel Corion, you will see that what had happened is that the previous owners had held it as joint tenants. And it recites very carefully, as each of them has died without having parted with any part of their interest in the estate, until we get to the penultimate survivor, and then it recites her death and the fact that she died without parting with any, and I think that might have been in 1908 or sometime, and then the last man standing, if you like, then conveys all of the estate to Samuel Corion. But of course, no plan, no even description of the boundaries. So the problem confronting the courts below is the problem. And of course, extrinsic evidence required. Again, my learned friend accepts that. He says, oh, you should have perhaps brought history books. I think at one stage, and we failed to do that. But what would the courts below have said, or what would he have said to the panel had we been relying on history books as opposed to the 1904 plan? Well, how do you know? I mean, was this historian a reliable historian or not? You know, and how many people write history books about where the boundaries of a particular parcel of land begin and end? They may tell stories of what was cultivated on the Grenada's estate, but you know, the idea that we would get an answer to this problem in history books, in my respectful submission, is fanciful. Similarly, he started to say and then hesitated, well, we didn't bring any witnesses to talk about what people understood the borders and the boundaries of the Grenada's estate were back in 1885 and 1904, but of course they're dead, and he understood that. So it is in that context we go to the nearest and best evidence that in fact was available, which I respectfully submit is this critically important 1904 plan. Because the surveyor who produced this plan, no doubt, is dead. But he left, as one might in a history book, a record of what he observed, what he understood, and what he regarded as accurate about this area of land that he included within his survey. That is what this survey plan does. So he speaks to us from beyond the grave. And the plan, if I take you to the plan, it says it's showing the boundaries of the Harveyvale estate, situated in Carriacou, surveyed by order of the Director of Surveys under the Boundary Settlement Ordinance number 2. And I'm not going to take you again to it, my lords. I've had the benefit already of being shown the Boundaries Settlement Ordinance, and you see that it's given a particular status if the survey is carried out under that particular ordinance, and that there's a process that allows anyone who is aggrieved or unsure, or who does not agree with what the survey says, a process by which you can come forward and challenge it. And that process is statutorily defined. And if that process is not engaged, then the plan, which is lodged officially with the government of Grenada, is deemed to be accurate, deemed to be correct. So we have someone speaking, as I say, from beyond the grave, who was around much closer to the time than we can ever be, who has recorded what he believes the position accurately to be, and what he has recorded is deemed by law to be accurate. And then you see the plan is, of course, of the Harveyvale estate, and it's laid out in a number of lots, and in addition to the lots, within the Harveyvale estates, it identifies by gray shading what are called reserved areas. So, for example, if you look just to the south of the swamp area that we focused on this morning, you see an area with 2 ponds, and that is shaded gray, and it is measured, and boundary marks are put on it, and it is measured at 22 acres, 3 roods, and 14 perches, I believe is the word. And of course, if you go across to the memorandum on the right, where you have the key to how the plan works, you'll see that reservations shown thus, and the gray shading is shown.
In what sense is it reserved?
Again, I wasn't there, and I'm not a surveyor, but my understanding when we look at all the areas of reserve, it wasn't laid out in lots.
Right.
So everything else seems to be laid out in lots, but areas which either were suitable to be laid out in lots, which I think is largely what you will find, or areas which were reserved from being laid out in lots of other reasons. For example, if you go just to the east of that area, I was focusing on the 23-acre area, you'll see there's a cemetery.
Yes.
And that too is reserved, and that's measured out, and you see it has the boundary marks, 3 acres, 3 roots, 3 perches. So it's within the Harveyvale estate, and therefore it's part of this survey, but it's just not a plot. It's not a lot. It's a reserved area within the Harveyvale estate, but it's still part of the survey. And you can see it's marked with the little round circles. If you look around the boundary of the cemetery, you see some areas there are little round circles, and in some areas there are little black circles shaded in. And if you go to the memorandum, you see that the circles that are solid are boundary stones with lot numbers, thus, and the ones that are boundary stones without numbers are and boundary stations are thus are the circles that are empty. They're not solid. As my lord and my lady see, that is what the surveyor from beyond the grave has given us as an aid to understanding his work. And of course, each of the shaded areas representing the reserves has carefully marked the acreage. So the one to the furthest east, to the west, to the furthest east, has 14 acres, 2 roots, 20 perches. The one which looks like a hilly area, and therefore presumably not suitable for lots in reserve. And the one right down in the south has 15 acres, 14 roots and 38 perches, again not suitable and reserved. And even where he's not reserving, and I'm saying he, but I suppose it could conceptually be a she, partly my prejudices, but I suspect if we're talking in 1904, I might be permitted to make that assumption. But if we look right down at the bottom, even where it's not in a reserve area, there's obviously some type of hill right in the very south of the Harveyvale estate, and he shows where that is by kind of drawing in the topographical feature. I don't know if you can see that, but again, I'm not trying to give expert evidence on this, but to me that's pretty obvious reading that there's a topographical feature there. And it's a similar topographical feature that you see up near to 8, just above that. Now, the other thing he takes great care to do is that, and this again, I'm sorry, I forget which one of your lordships or my lady made this, or posed this as a question to my learned friend, but in every location along the edge of the estate, he identifies the neighboring estate with great care. Every occasion. Hermitage, down in the left bottom corner, which you see, and then the sea is below it, because the sea obviously, this is at the end of the island, so the sea is to the south. Corby to the east in the south. Then Industry Estate, Belmont Estate, Endeavour Estate, Argyle Estate. So if we take, for example, that's an example. I'm sorry to dwell on this, but it's important given how little credit my learned friend gave to this plan. He said he could provide no probative evidence. Because he did accept again that once there was any probative evidence as to this finding, then his client couldn't challenge it under the principle that my lords had raised with him in the morning. And he said it had no probative value. So go to lot 11, because it's easy to find right down at the bottom of the plan. So right down in the southwest. If someone who had bought lot 11 at any stage wanted to know, well, who is my neighbor to the west of me? He could have found out it was Hermitage Estate. And if he wanted to know, well, where is the boundary between me and my neighbor being the Hermitage Estate, he could have seen exactly where it is located there. But of course, similarly, if the owner of Hermitage Estate didn't have a survey for whatever reason, And they wanted to know, well, who is my neighbor down in the south-easterly part of my estate? He could go there and see that the owner of lot 11 was his neighbor. And he could see exactly where his boundary, the owner of Hermitage, his or her boundary, the owner of Hermitage estate was with lot 11, therefore with the Grenada estate. Because that's how boundaries work. They're a line between two properties, and it's the same line. It's I guess, notionally thin. Once you define that line for one purpose, by definition, you define it for the other. And you can go all around and see that applies throughout the plan. But let us go up to where really matters. So going around the world, let us return to the swamp area. The swamp area to the northwest of the Harvey Vale estate is surveyed by the surveyor in 1904. And he labels it as swamp, and he shades it as reserved, and he gives its measurement as 4 acres, 2 roads, and 0 perches, as he does with all of the other reserved areas. And as he does with all of the other reserved areas...
Can you help me with those figures? My eyes are not good enough to make out the acreage there.
The acreage there is 4 acres, 2 roads, 0 purchases, is what the surveyor put it at.
It's clearer if you go to page 517 in the electronic bundle.
And enlarge it.
Thank you very much.
Yeah.
So it is clear that it was part of the surveyor's job, and it is what he was doing under the boundary settlements order, and it's what he did, to define that area that he shows as the swamp reserve, 4 acres, 2 roads, 0 perches. And he draws a boundary across the north of it, which follows almost exactly the same line as the public road that's leading up to that point. Unsurprising that that might be where the boundary lay. As I think it was Lord Richards that observed, a surveyor would have little difficulty in understanding this morning. And at each end of that boundary to the north of the swamp, there is the symbol that represents boundary stones without numbers and boundary stations. There's the empty circles. There's the empty circle to the east, right at the junction in the road. You can see it if you look carefully. I mean, obviously, a magnifying glass would help, but I think it's quite clearly there.
And those are boundary stones, the empty circles.
There's a boundary stone just at that junction, marking that edge, that end of the boundary of the swamp. And if you go west along the line, at the point where the land stops and the sea begins, I suggest, you have another boundary stone. Now, I'll come back to this very briefly in due course, but whilst I'm there, let me just make this point, on the foreshore point, which I'm not dealing with at the moment. The suggestion that this surveyor, who is the best witness we have, I say, speaking to us through this plan, was putting boundary stones in the sea, rather than putting them where, given that we all accept now that the common law presumptions of foreshore ownership apply, etc., in Grenada. If you are a surveyor and you're going out and you're trying to mark the lines between a property and the sea, the presumption must be, and of course this was never inquired into because the point was never raised at the stage of evidence, But the common sense presumption must be that you're going to do it where the boundary between the landowner's land is and where the Crown's rights might begin. And you're certainly not going to swim out into the sea and put a boundary stone somewhere where the height is below the high water mark. But that, I digress in a sense, but I think the point is there because I don't want to spend too much time when I come back to it. It's just, from the planet, it's, in my respectful position, obvious. But what is equally obvious is that immediately above, i.e. to the north of where that boundary line is drawn, the surveyor has taken care to tell us who is the adjoining, the neighboring landowner. And it is the Grenada's estate. And that is exactly the area of the location of the disputed land. And that is why I said what was important was determining the relevant boundaries of the Grenada's estate. Of course, my learned friend is right that you can't determine the boundaries of the Grenada's estate by reference to this plan, because the Grenada's estate clearly stretches way north of this plan and possibly further east of this plan. So if there was a boundary problem, or if there was a land dispute problem somewhere else on the Grenada's estate, clearly this is of no help. But fortunately for the courts below, you had a witness who could speak from the grave and tell us that I drew a line which marked the northern boundary of the swamp in the Harveyvale estate in this exact location. And necessarily by doing that, told us that that was the line that marked the southern boundary of the land on the other side, and then told us who owned that land on the other side, i.e. it was the Grenada's estate owner. Now, my little friend made heavy weather of the fact that, there's a triangle line, a diagonal line running there and so on, and, he wouldn't want to put it there, and therefore placing it where he placed it, you can't make any, it had no probative value, had no significance. And of course, first of all, that's factually incorrect. If you look immediately, if you look at the south of the document, of the plan, where it says Industry Estate, Belmont Estate, so near the right-hand rectangle at the bottom, I don't know if my lord and my lady see it.
Sorry, can you help me again?
If you look at the middle of the plan, but to the south, so if you go
just above the box reference.
just above, thank you, my lady, much better way of putting it. If you look just above the reference to traverse,
Yes.
you see there's the Industry Estate and the Belmont Estate shown as both neighboring landowners. Yeah? The simple point is when he drew one of these, I don't know if they're triangulation lines, I'm not sure what the technical word is, but one of these things that are not boundary lines, he had no difficulty putting those names exactly where the lines were. And it doesn't obscure the names. Of course it doesn't, it's a tiny little thin line. And similarly, another example, I mean, again, it's not important, but if you look where, just by the cemetery, just to the right, well, if you look at the cemetery, just to the right of the cemetery, you see there's a reserve area that describes buildings and something else there. He runs the line straight through the word buildings. So there was no obsession on the part of this surveyor to tell the people he was leaving this plan for that I don't like running lines through where I write words. He put Grenada's estate there because he was leaving a record of the fact that the lands immediately to the north of that boundary line that he drew and identified the boundary stones at either end of the line was part of the Grenada's estate. So unless we could, as I say, find someone who was still alive, unless we could find a history book that happened to speak about where these lines were drawn, which, you know, is extremely unlikely, we found, fortunately I say, my clients found a plan that had been drawn roughly contemporaneously with the two conveyances, in between the two, which has evidence from somebody who understood where the Grenada estate was at the time, understood that where its boundaries were at the time, who conducted a professional job of recording where they were at the time. Unfortunately, in the particular area which we concerned, actually identified that the disputed lands fell within the Grenada estate. Now, the second reason my learned friend says, however, he says, even if that's, well, he doesn't say even that's so, he says that's not so, but I now respectfully say it is so. But he says there's another problem, so I guess I should put it, with using, or the courts below, using the Harvey Vale plan. And it is, of course, we don't know, there might have been some disposition, some sales of the properties after the 1904 plan was drawn and before the 1914 conveyance. And of course, anything is possible. But one has to decide, the courts below had to decide these things on a balance of probabilities. And again, as I think Lord Briggs observed, I mean, even if there had been some conveyances of this land in that 10-year period, what are the chances that it happens to be that it's exactly this disputed 7 acres out of this much larger estate that were the parts that were disposed of? So if you had to, if there was nothing else, even if it's just almost mathematically one were looking at it, you'd have to say, well, you know, all else being equal, it is far less likely than not.
We'd also envisage having sold those specific 7 acres of land, but then the purchaser not apparently doing anything with those acres of land, having bought them.
Exactly. And all of the evidence suggests otherwise. But there is actually more than that. Because I invite my lords and my lady to go to the evidence of Mr. Masaki, who was the surveyor expert called by the state, the Attorney General, to give the court evidence on this title point at the hearing of the preliminary question of who held title to the land. And if we could go to page, if I could invite my lords and my lady to go to page 506. 506 of the electronic bundle. So he identifies himself as the Director of Lands and Surveys in the Ministry of Agriculture. So he comes with position. At 1.1 he says he's a registered land surveyor since 1998 and he's occupied the post of Director of Lands and Surveys since 2007. 1.2, I'm familiar with the parcel of land that is before the court for determination of the preliminary point of ownership on account of the duties of my office as Director of Lands and Surveys. And I swear this affidavit further to an order of the court that affidavits regarding ownership be filed in this matter. And then first of all, if I take you to 4.4, across the page at 508, this is what the Director of Lands and Surveys, the state's witness who's sworn his affidavit for the purpose of the preliminary point, tells the court below. The records at Lands and Surveys indicate that Grenada's estate is bounded by Harveyvale Estate to the south, Monpose Estate to the east, and Tyrrell Bay or Great Carnage to the west. According to the registered survey plan conducted by order of the Director of Surveys under the Boundary Settlement Ordinance number 2, containing 331 acres, a copy is annexed VM2. Of course, that's the identical 1904 plan that my learned friend says he's submitting has no probative evidence for value whatsoever. So according to the records of the Lands and Surveys Department of the Government of Grenada, as confirmed by the director of that department in his affidavit evidence to the court, what they show at the date of his affidavit, 28th of February 2017, is that the Grenada's estate is bounded by these things, and he's making that point by reference to the very plan. Because he doesn't say that they show, because he's submitting this in support of the state arguing that they own the land, he doesn't say that it also shows that it is bounded by the Grenada's estate to the north of the area shown as a swamp. But that is just because he doesn't say that. The logic of what he says is that that's what their records also show as at 28th of February 2017.
Is VM2 in the bundle? Well, you say it's the 1904 plan, but it doesn't seem to fit its description in paragraph 4.4. Because somebody looking at VM2 has gathered that to the east of the Grandance estate is the Monpose estate. And I don't quite... Oh, I can see it's just up in that corner, yes. But anyway, VM2 presumably is in the record somewhere.
Well, it's not attached as VM2 because they were removed from the thing, but I do represent you, and I invite my learned friends to check this. But if you look, you'll see it says, by order of the Director of Surveys, containing 31 acres, 2 routes, 30 poles, which is exactly what 1904 says. My instructions are...
Okay.
Right. Lord, we agree with that.
Okay.
It is a reference to the 1904 plan. We're at one on that point at least.
Thank you.
What's he referring to in 4.5, that the southern boundary line does not conform to the northern boundary line of the Harveyvale estate?
Yeah. Well, that's what he says, because of course, you know, his job, as I'm afraid, was to dispute the claim. So he's saying that the 1980 survey done by Mr. Thomas, which was the other large plan that you were given, that the line that was drawn, the equivalent line there, doesn't conform to the line on this plan. But we could look at that, and it may be, I guess, I don't know, I'm not a surveyor again, it may be incrementally different in some way, but for any practical purposes, it looks identical, certainly to me. But the point I'm making is here you have the official government confirming that they're using this plan in 2817. So the idea that things have changed and you can't use it and all this thing, first of all, you know, is inconsistent with the evidence that was before the courts below. And of course, it's not for my lords to decide the point. The point is, you know, did those courts have evidence that they were entitled to rely upon, etc. But just turn back briefly to 4.1 at page 507, just to complete this, and then I promise you I'll move on from this affidavit. The first sentence of 4.1, the disputed parcel is located in the extreme lower left-hand portion of the land as depicted in Exhibit B to the affidavit, and so and so. My research has revealed no file conveyance of that portion of the land to any person. So even if they had been, some conveyances between 1904 and 1914, as my learned friend speculates, quite apart from the sort of statistical, as it were, approach to working out how likely it was a swamp land. We have the evidence from the expert that the state put forward to assist the court on this question, who is the director of land, saying that his research has revealed no file portion of that portion of the land. And that is uncontradicted. So again, on a balance of probabilities, the court was certainly entitled on that basis alone, in my respectful submission, to make the findings. But let's also go to the CDC's, this appellant's own expert, Mr. Thomas. If I could ask the lady and my lords to go to page 491. And there, you know, at 491, he introduces himself, 60 years old and a licensed land surveyor, practiced for 33 years, worked extensively and actively throughout the islands of Grenada, Carriacou, and Petit Martinique. Carriacou and Petit Martinique are the two larger of the small islands of Grenada. And he's the president of his own firm. Paragraph 3 says, I'm familiar with a lot of land situated Harvey Vale, the subject of this suit, the disputed property. So he tells us he's familiar with the disputed property. And then at paragraph 4, I'm also familiar with a larger lot of land, formerly referred to as Grenada's estate, which is referred to by the claimants as forming part of the estate of Samuel Corion. So he's familiar with both the disputed parcel and with the Grenada's estate, the larger parcel. And then go across the page to 493 at the top of the page, paragraph 10. Sometime in or about 2013, I was contacted in relation to the question of title to Grenada's estate, and thereupon had cause to peruse the deeds and plans in relation to sale. So of course this was in connection with the very preliminary determination issued the court started, and he is the man that they go to and say, we consult you, and as a result of that, he perused the deeds and plans in relation to the question of title to the Grenada's estate. And he's put forward by this appellant. And then at 11, under the heading Title and Survey Documents Reference, I have had reference to the following documents in order to ascertain the question of title to the said Grenada's estate. A. Indenture of appointment dated 9 June 1885. So that's the 1885 conveyance that we've already looked at. B. Indenture of conveyance dated the 19th of February 1914 between Henry St. Barb Goldsmith and another, and the deceased of the other part. So that's, of course, the 1914 conveyance to Samuel Corion that we've already looked at. The 1980 plan, that is his 1980 plan, the second of the two large plans that were handed up. And we will, if my lords and my lady allow me, turn to that at some stage very briefly. D. Indenture of conveyance made the 17th of October 85 between Oliver Corion and others and Roosevelt Churchill Corion, and recorded in the Deeds and Land Registry, a 2-copy of the indenture. That is, I believe, subject to correction, a strangely shaped piece of land with the, is it the dog leg? I think the golfing term, one of your lordships adopted this morning that was done, and I think we confirmed that was sold. So that's that piece of land, which of course extends all the way across the north of the disputed parcel. And that was sold from basically the estate of Corion. What happened is Oliver Corion, we can go to it, I don't have the reference with me, but you'll see if I find it for you. Oliver Corion got permission, he was appointed, I'm not good at the Latin phrases and so on, but he was given title as an administrator of the estate of Samuel Corion purely for the purpose of doing this. And so this was really a sale by the estate, even though it says by Oliver Corion. But the point is that land was sold by the estate to the north of the disputed land. Then he refers to the indenture of conveyance between Churchill Corion and Alexis, recorded in so and so.
Could you just, in these descriptions, it says, in relation to each of these, recorded in the Deeds and Land Registry of Grenada in Liber M6 or Liber V7, Liber V13. Do you know what that is? Is that referring to where in the archive of the Land Registry this is found, or what is?
Let me just see if I can get, I believe so, but let me see. That's exactly what it is. It's a page number within the archival records of the public registry.
Right, so these documents that we've been looking at are drawn, some of them at least, are drawn from the public registry.
The deeds are, yes. The conveyances are. It's unregistered land system in the sense that
Yes,
you don't have a
understand.
registered
But
title.
rather than in a shoebox under Samuel
exactly.
Corion's bed or something.
Exactly. It's an unregistered land system in the sense that you don't have a Torrens registered land arrangement. But there is a...
But there's a deeds registry.
But there's a deed registry, and these are the references to the to where they are stored and where they can be accessed. And so that's what Mr. Thomas, the expert for the appellant, is doing. And then he comes down to the survey plan of Godwin Alexis, and then a G, because I'm more interested in the title effort that he made on the plans at this stage. G, a title search referencing several other conveyances purportedly coming from the estate of the deceased. And the question was asked, I think this morning, were there any evidence of other conveyances? And this doesn't really matter that much in my respectful submission, but it does matter a little. There was evidence, and in fact, in the courts below, the appellant relied very heavily on the existence and the evidence that they produced of there being these other conveyances of parts of the Grenada estate, obviously subsequent to Samuel Corion and the Corion family acquiring it. And they were saying, in fact, they had sold more than the 106 acres of land. That was the theory they were running, as it were, in the court below. How could you still own the disputed land when you bought 106.5 acres and you sold already more than 106 acres? And that's what this evidence of Thomas was designed to support. But of course that doesn't go to whether they disputed land or not. What that does tend to suggest is either they acquired more land at other stages, we don't know, or more likely, in my respectful submission, though of course we don't have, the court can't, and courts below couldn't, and this board doesn't have to be more likely that there may have been a mistake in the 1914 deed, as the judge thought. And the little friend says, oh, that's so unlikely because someone took great care and interlineated and 1/2. And I understand the point. But if frankly someone is writing these deeds, it is a writing clerk. Certainly in Trinidad when I practiced, we used to call them writing clerks. I was old enough that although I never met a writing clerk, I heard of them. And someone would have said to this writing clerk, write this out, and might have said 160.5, and the person heard 106.5. It's not that inconceivable. We don't know. But the idea that the Corions could have been selling off all this land way in excess of what they actually owned over all these years, and nobody ever noticed. None of the conveyancers who were representing these purchasers ever stopped to say, well, hang on a second, what's going on here? On a balance of probabilities, that theory that they ran, which again, to their credit, they're not running here, just doesn't add up. But the point is, there was Mr. Thomas for the CDC, for this appellant, identified the transactions that had occurred going back from the original transaction in 1885 and coming right up beyond that to post the ownership of Samuel, because he said he had been consulted on the question of the title of the Grand Estate and had cause to peruse the deeds and plans in relation to that. And no suggestion to support their speculation from their witness, whose job it was to provide the facts, that there was any basis for saying that, oh, there had been these conveyances and therefore you can't trust or you can't use, or it's of no probative value, the 1904 plan.
He doesn't consider the 1904 plan in this statement.
He doesn't. Interestingly, the one plan that he doesn't tackle is the 1904 plan. I can't explain it, but he doesn't. The Lord is absolutely correct. What he does mention is his own plan done in 1980. And I wonder if I could invite my lords to just very briefly look at that, because we don't put a huge amount of weight on this, but the point is this was their evidence, their witness, and he was confronted with this, as you might expect. Now this is a plan he drew of the Grenada estate, which he told us he was familiar with. And crucially, because the important area is if you go to the southwest of it, you see Government of Grenada. And of course that corresponds, if not identically, almost identically, to the same boundary that marked the northern edge of the swamp area in the Harveyvale estate. Because you can see the crossroads that's right next to it on both plans. And you can see the slope of the line, and you can see where it reaches the coast. I mean, a comparison of it, I mean, it certainly suggests that in 1980, this land was very much like what it was in 1904. So this idea that somehow we've had all these hurricanes that have changed where the foreshore is and the world has become different, it's speculative possible. But Mr. Thomas didn't think so. And then he shows Lot 1, 34 acres, and clearly the bottom part, the southern part of Lot 1 is the disputed land. And he shows that, of course, as being part of the Grenada estate. It's in 1980, so again, less helpful than the 1904 plan, but it's consistent with it. So the witness for CDC, when he did this plan before there was a dispute, and before he had, as it were, a team to back it, I might put it that way, he put it within the Grenada estate. Now the way he explains this, he says, oh, well, I did this for Roosevelt Corion, and I relied entirely on him marking out the boundaries, and I didn't consult the deeds and so on. But the idea that this man, who is a licensed surveyor and a professional, literally served the purpose of drawing because Roosevelt Corion couldn't draw so well. So all this represents is what Mr. Roosevelt Corion sought. He was just a scribe in that sense, a drawing clerk. Of course, is outrageous. He must have used his professional judgment. Yes, the client would have taken him and said, these are the lands that we know to be the Corion lands. This is where we used to go. This is, look, this is the boundary here. This is why we think it's the boundary. It's an extension of the road. But he's a surveyor. And he's not just going to create a plan that just represents some fantasy. And he doesn't, because he draws that line, that crucial line, exactly where you might expect him to draw it, because it corresponds with the best evidence from the 1904 plan. And he does exactly what the 1904 plan, which he shows it as Corion land. The 1904 plan shows Corion land, he shows it as Corion land. So this wasn't some fantasy of Mr. Roosevelt Corion that he was just drawing for him. And just for completeness on Mr. Thomas, and I think my little friend took you to this, but if we could go to page 641 in the record. get the lease between the government and CDC, the appellant, with respect to the first parcel, the undisputed parcel, which, as we know, formed part of the Harveyvale estate. And the record shows, I mean, I can't put my finger on it now, but I don't think it's disputed, that by the time this lease was done, the government had bought that part of Harveyvale estate, so it was selling it because...
I don't recall anything in the evidence
Okay,
to that effect.
All right, it's in the evidence, and I can find it if necessary. I believe it may be either McCaskey or could be Thomas himself, but somebody said that this was Crown.
Well, the plan we just looked at, the 1980 plan, shows the government as owning this property.
Yeah, thank you, my lord. But it's also there somewhere. It doesn't matter. But I promise you that I saw that somewhere. There wasn't in the courts below. We looked for it. I hope. And if I'm wrong about it, I'll apologize. It really doesn't matter. But the Crown somehow owned it, and this lease, or at least they said they owned it, and they made this lease. The point for this purpose is if you go, there's a plan attached to that done by Mr. Thomas. And of course, my learned friend took you to that, and I'll just take you back again at 659. And the point was already made through the questions to my learned friend that, of course, at the top of it, the same area that he showed as being part of the Corion lands in his 1980 lease, with the same boundary to the north of Lot A, he now doesn't say lands of Corion like 1980, but he says private lands. And of course, that's inconsistent with it being Crown lands, but consistent with it being Corion lands. So he's remained consistent. He's just been less specific. And of course, again, one of the lords or my lady pointed out that where it was Crown lands, right at the bottom, above the jetty, he marked it Crown lands. So again, just as the 1904 surveyor was careful to identify neighboring adjoining parcels, he does that in the same sort of way, and he identifies also the estate of Lendor. So in a nutshell, the competing claims to have title to this land were between the state, subject to the foreshore presumption, my lords and my lady. The competing claims of the two title holders, because the appellant never claimed to have any sort of claim to have title. The two competing claims of title were state, Corions. I say there's not just good evidence. There was abundant evidence, not perfect because this was all went on a long time ago, but there was probative, real evidence, and on a balance of probabilities suggests that the boundary, the relevant boundary of the Grenada estate was that boundary to the southwest of what was the Grenada estate and to the north of the swamp that was within Harveyvale, and that the disputed land which lay to the north of that boundary was therefore part of the Harveyvale, part of the Grenada estate conveyed to Corion in 1940. I say that's the overwhelming conclusion of such evidence as there is, way beyond a balance of probabilities, but in any event, that's not the question really with respect for the board. The question is, did the courts below have any sort of sufficient probative evidence that could have justified arriving at those conclusions with the benefit that they have of understanding local conditions, etc. They did, and there's absolutely no proper basis in my respectful submission for those findings to be upset. Move on. Yeah. So, my lord, turning then to the second and last point.
Well, before you move on, can you just help me? There were other items of evidence relied on at first instance and by the Court of Appeal, which were said to be probative. It included the recollection of witnesses of certain parts of the estate. What do you say about that?
Yeah, much obliged. Yes, my lord, I didn't mean to suggest that there weren't other evidence that's consistent with what I have presented. There are. and all of it is consistent and corroborative, if you like. And of course, they corroborate each other because, you know, one might well say of some of this sort of witness statements, you know, sort of, oh, the Corions are bound to say that, right? I mean, just as I accused Mr. Thomas of being a little bit partisan when he decided to downplay what he represented in 1980, I'm going to accept that you could expect that, you know, if we were relying purely on Margaret Corion to tell us where this boundary is, we'd have to be careful. Well, the courts below would have had to be careful in assessing that. But it's corroborative, and yes, that evidence does exist as well, the evidence of them always treating it as their land, the evidence of the fact that the neighbor always understood it was their land, the fact that they sold off land and nobody ever complained about it, the fact that they sold the land immediately to the north of that parcel, that's obviously contiguous with it, and part of it at least is the same swamp. And there's been no challenge or complaint about that as far as, you know, all of that, my lord, all that together are bricks in the wall. But I hope that I've highlighted what I regard to be, you know.
One further thing before you move on. It said that Mr. Thomas, in the course of his cross-examination, admitted that the land that the disputed land was the property of the estate. Do you maintain that?
No, my lord. My lord, I accept that the judge put it in too strong a manner. What happened is that Mr. Thomas was confronted with his 1980 plan, and he had to admit that which he had to admit. So he admitted that he had, in fact, recognized the land by reason of putting it on his plan as being Corion land. And he admitted that on his other plan he had shown it as private land, but he didn't actually then sort of link those two together and say, now I recant from what I'm saying and I say that therefore the land is Corion land. He didn't go that far. I think the judge felt that effectively when he recognizes that he himself had called it private land and not Crown land, even when he was doing the survey for the appellant and for the Crown.
So it was a comparison of the 1980 plan and the 2005 lease plan?
Yes, exactly.
Thank you. And
so I think the judge...
Can you give us the reference to that passage in the cross-examination? I'm not asking you to take us to it.
The reference in, sorry, my lord?
In the cross-examination. I'm not asking you to take us to it.
Yeah, my lord, could...
Yes, we'll have that later. We'll have that later. Thank you.
Sorry, my lord.
That deals with my point. Thank you very much.
So should I turn now to the foreshore, the seabed and foreshore presumption?
Yes, please. Thank you.
Thank you, my lord. Now, my lord, as already been observed, of course, this issue arose for the first time in the written submissions of CDC, which were filed after the hearing had closed and the evidence had been heard. But I do ask you to go briefly to those written submissions to see just how faintly it arose as well, because I think fairness to the trial judge requires that in a sense. If you go to page 89, you see where that submission is raised. '89 of the electronic record, at paragraphs 37 and 38 under a heading, Prerogative Right of the Crown. 37, submitted that by prerogative right, the Crown is prima facie the owner of all land covered by the narrow seas adjoining the coast or by arms of the sea or public navigable rivers and also of the foreshore. Footnote 16 to Halsbury's laws. It is a fundamental principle of law that all the land in the realm belonged originally to the monarch. So you know, a sort of a quote or a paraphrase of one section of Halsbury's. 38. Having regard to the nature of the disputed property, it is submitted to the same as at all material time lands of the Crown and remains so, notwithstanding the claimant's claims. So, not only was it not raised as a matter of pleading or even flagged as an issue before the evidence was done, but when it was submitted in the closing submissions, it was hardly submitted at all. All that was said is having regard to the nature of the disputed property. That's it. So it's hardly surprising there was no objection from anybody, because it just, frankly, was nothing.
There's no presumption raised here.
Nothing. So when the judge, that's why I say out of fairness to the judge, when the judge dismissed the argument in equally brief and terse terms, to be fair to her, she was right to do so. And you'll see that she did that at page 98. Paragraph 19. The defendant's submission that given the nature of the property, it being swamplands, by prerogative right, the Crown is prima facie the owner. As Mr. Allain says, and I agree, although the disputed land may be referred to as swamplands, that does not make it Crown lands. She then goes on to accept the other submission, which that Miller and friends spent some time on, but which we don't make, we didn't pursue. The point is, this is the real thing. You know. So she answered the question, all this is by the nature of the land. She actually identified what the nature of the land they must have been referring to, which is the swamplands. And she said, well, I don't agree. So she made a finding that they had not proven, as it were, the trigger fact for the presumption to apply, because the mere fact that you show that lands are swamplands doesn't give rise to the presumption. You have to show, in my respectful submission, as I'll say shortly, that the lands form part of the seashore, the seabed, and therefore on the landward side of the mean high water mark.
And so far as the further point she goes on to address concerning the Crown lands appearing in the statute, you're not pursuing that?
No, my lord. No, my lord.
Was it pursued in the Court of Appeal?
I don't think so. Was the Crown lands further point pursued in the Court of Appeal?
Anyway.
I think the Court of Appeal referred to it as well.
Yes, yes.
It's not pursued now, and it's accepted that it's wrong.
No,
thank you very much.
Well, what we see on this is the judge dismissed this claim, this aspect of their claim that the Crown had prerogative on the basis of a finding that they had failed to satisfy the burden of showing that it was seabed or foreshore, and therefore that the foreshore presumption arose. She did it in very brief terms because it was presented to her in very brief terms. She said, well, given the nature of the land, she said, no, you can't do that. You can't say given the nature of the land, it applies. You have to do more. You haven't met the burden. That's effectively what she said. The Court of Appeal had the benefit of much fuller argument on it, very full argument on it. But they essentially came to the same conclusion. They came to the conclusion that the test was not whether the land was swampland or land covered by water, but rather whether the land was or was not below, meaning to the seaward side of the main high water mark.
And that you would discover mainly by looking, for example, at a chart. I mean, Admiralty charts are quite precise about where the mean high water mark is.
So, my lord, again, the Court of Appeal may have slightly overstated the position. I'll go to it in a minute and see that, that you could understand why they would have done it. Because there will be exceptions, and my learned friend, very sensibly, my learned friends, in their written case, and to some extent this morning, go to the exceptions, right? They say, well, there must be cases where you don't have to prove exactly where the mean high water mark is. And we accept that. There will be extraordinary, we say the extraordinary cases though, where it is so obvious on the facts that wherever the mean high water mark might be, the particular land in question is on the seaward side of it. So it would obviously be pedantic and silly to suggest that in a case like that, you've got to go and get technical evidence and have someone actually draw the line, as it were. Whether that's done by reference to an established chart, or whether that's done by reference to surveying evidence, because surveyors do this. But that is exceptional, and they say, oh, an extreme example of it is where you have a fishery that's out at sea. But that's right. But almost any example which would meet their exception test will be an extreme example. Because by definition, the test of what is or is not foreshore is, does it lie to the seaward side of the mean high water mark? By definition, the mean high water mark is a notional line. You can't say, save in the most exceptional and extraordinary of circumstances, that something lies to the seaward side of that line unless you know where that line is. It's just common sense. And that's what the Court of Appeal was really saying. They may have slightly overstated it, but that's really what they were saying. Basically, they stated the rule correctly. They didn't acknowledge that to every rule there is an exception. But in any case, the exception can't and didn't apply here, because both courts below were right that on the evidence there was no possibility of the appellant satisfying the courts below that this was on the seaward side of the mean high water mark. And of course, my learned friend, in a sense, recognizes that difficulty, but he gets out of that difficulty by, my respectful submission, a device, sorry to use that word, that only has to be articulated to be rejected. And Milady Rose, of course, caused him to articulate it, which is that there's a presumption that there's a presumption. So he says, he realizes he can't say that this is a sort of a self-executing presumption, that every time there is a piece of land and you claim paper title to it, if there's even a remote possibility that the seabed or foreshore thing might apply, so you're on a links course, and therefore there's a sea boundary to it, you've got to go and get the mean high water mark established before you could claim a trespass anywhere on your property. He realizes that, that's a bridge too far. So he says, hang on, there's a kind of a lower threshold of evidentiary. So, there must be some water around, there must be some sense that there were some crabs on the land and people went for oysters, and maybe there's an area where people brought boats in and that sort of thing. And once there's some talk of water on the land and that kind of thing, but then there's now a presumption that the presumption will apply, and the owner shifts somehow onto the landowner, because remember, for this argument, we must presume that we have illegal title to the land, because otherwise he doesn't get to this alternative argument. So we own this land, we bought this land, we paid for this land. This is our land, unless it's foreshore. Before we can enjoy it, without them even showing that it's foreshore, they get the benefit of this strange presumption that there's a presumption, and puts the onus on us to go back and find where the Crown actually specifically granted it to us.
Was there a moment in Grenada's history when the Crown did parcel out all the land to everyone way back when?
Lady, I don't know. I mean, the only honest answer I can give you is I don't know, but I would say that my understanding is that, as in all of these colonies, everything would have originally have been the Crown's, because they were acquired essentially by discovery, as it would have been thought at the time. Now
or as in England by conquest.
By conquest.
But I mean, it'd be an interesting historical matter. I think that England acquired Grenada from France.
Yeah.
Isn't it? So did it respect French property title at that point, or we just don't know, do we?
My Lord, if you take...
But there may be a history book that tells us, of course.
but this is a separate point. I mean, lady asked the question, I believe, because my friend...
Yes, well, as I understood Mr. McGee's submission, that it's not enough for you to show, even if you could show that the 1914 conveyance and the 1885 conveyance purported to convey this disputed land, that would not be enough to rebut the presumption of foreshore ownership by the Crown, unless you could show some historic document that shows the Crown alienating the land to private interests at some earlier stage.
Yeah, that's correct. Milady, that was his
But I
submission.
don't know
as I
whether
understand.
that actually ever happened.
So, yeah, so Milady, that was his submission. I think Milady's understood it, certainly the way I understood it. I say two things to that. First of all, of course, we don't get to that until you show that the presumption arises at all. And that's where I say his case, in fact...
But I think I understand your underlying submission to be, I'm not sure you've quite spelt it out yet, that if the Crown, or anybody who's claiming title as a tenant or a licensee through the Crown, wants to rely upon the foreshore presumption, then they must satisfy the evidential burden of showing that the land in question is foreshore, i.e. below the mean high water mark.
That is exactly what I was trying to suggest, my lord. That is exactly right. And we give you the extract from Phipson at paragraph 56 of our printed case, page 768 of the electronic bundle.
Sorry, 768?
Sorry?
Did you say 768?
768 of the electronic
Thank
bundle.
you.
And then that was one of the materials that was omitted from the authorities in electronic records, so it was sent by email yesterday. But you'll see that that basically just makes the obvious point. I mean, the presumptions don't automatically arise. They apply in favor of a party upon the proof or admission of one fact, based upon which another fact is then presumed.
This is
Paragraph 66.
Paragraph 66, exactly, my lord.
769.
And that's how presumptions with respect must work.
And you say the fact that there are crabs there and water there isn't enough to establish that evidential...
The fact that you must prove for the second fact to be presumed, so if I might use the expression, trigger fact, the fact you must prove is that the area in question is foreshore. Once you show it is foreshore, you have proved one fact. That is the trigger fact, and then you benefit from the presumption thereafter that it belongs to the Crown. But that is a rebuttable presumption, though there are restrictions, I accept, as my learned friend says, on the ways in which you can rebut that presumption if it were to arise. But you must prove the trigger fact or it must be admitted. Now, I'm on the question of the fact that the courts below concurrently found that the trigger fact, i.e. that this was foreshore below, that is to say on the seaward side of the high water mark, that burden hadn't been satisfied. And I say that's the end of the argument. Of course, in the alternative, we get to Milady's question. If I'm wrong about that, and in fact, this court feels capable of looking behind those decisions of the courts below and of overruling those decisions of the court below and saying, no, we think there's enough factual evidence here for us to find that this land was on the seaward side of the high water mark, and therefore the presumption was triggered, then we get the learned friend's submission of how can my client rebut it. He says it can only be rebutted by proving a direct grant from the Crown and not by going back to the normal route of title.
Or by adverse possession.
Or by adverse possession. And the accepted adverse possession, of course, is conceptually available. Though, again, like his example with the offshore thing would be, rare. But leaving aside adverse possession, and he read a passage, but we give you another passage, which I'll give you the reference to in a minute, at page 828, which is not inconsistent with what he says, but is a fuller description of the real position, in my respect, accurate position. This is from the House of Lords in the Attorney General and John Emerson and others.
Yeah.
And it's the judgment of Lord Herschel In the second paragraph on page 8.
Bear with us 1 second, if you would, please.
Sorry, Miller.
Yes.
Second paragraph on page 820, it says, it's beyond dispute that the Crown is prima facie entitled every part of the foreshore between high and low water mark.
I'm so sorry, which page are you on now?
828 in the electronic bundle. It's right at the start of Lord Herschel's judgment.
Oh, I've got it, yes, yes.
Second paragraph.
Yeah.
It's beyond dispute that the Crown is prima facie entitled every part of the foreshore between high and low water mark, and that the subject can only establish a title to any part of that foreshore, either by proving an express grant thereof from the Crown, or by giving evidence from which such a grant, though not capable of being produced, will be presumed. So there's a gloss, as it were, on what my learned friend said. You don't actually have to produce the grant from the Crown. You could also say if there's evidence from which such a grant could be presumed. Because this passage doesn't deal with the other possibility of adverse possession, whereas his passage did. But I think if you put them together, you'll see that the true principle is you can rebut it either by proving an express grant from the Crown, or by evidence from which such a grant can be presumed even if it can't be produced, or by adverse possession. And we say in the alternative that if you even got here, that of course, not so much in 1914, but the 1904 plan, which shows that it's part of the Abbeville estate, and then the 1870.
So you say the same evidence that you rely on?
The same evidence. If that was foreshore, then it had been put in private lands a very long time ago, from which is to be presumed that there must have been an express grant of the Crown if the foreshore had been handed over, as it were, if title to it had been handed over. But that's not... Sorry, I just deal with that there, because I don't think we get to that, my lord. That's very much...
Presumed grant, at least in the law of easements, is a rather technical subject. I'm just sort of searching for a little box in my memory that tells us how you presume this type of grant, presumed Crown grant.
My lord, the truth is this is not something that I have looked deeply into, because really my primary position, which I advance, is we don't get there because the courts below were right that all of this interesting is academic, because to get But you have to have the trigger fact. You must have some credible evidence that this is foreshore, or else how can you claim foreshore presumption? Now, to deal with that, Millennial Friends' main point in their printed case are two places in their printed case, and again this morning, and he tried to hold the ground under some very probing questioning, but was that they seized on a passage in the Court of Appeal judgment to then say it is common ground that almost the entirety of the disputed land was covered by seawater. That's how they put it. Because, of course, they understand, in my respectful submission, that if they're going to get past the difficulty of not having given any evidence of where the line is, they need a pretty extreme case. So the closest they could come to get themselves to that extreme exception case is to say, well, hang on, it's common ground that almost the entirety of the disputed land was covered by seawater. Now, even if that was so, I respectfully suggest that's not enough, because we don't know how long it's covered for. We don't know whether it's covered because there was a hurricane, and there's all kinds of permutations and combinations. Even if it were the case, it's just not sufficient. It would not be obvious that this land lies to the seaward side of the Menai watermark. But with respect, that is not quite a fair characterization either of what the Court of Appeal judgment was saying, nor more so of the evidence, so that to the extent that the Court of Appeal could be read as supporting this, then the Court of Appeal was wrong. But I think, to be fair to the Court of Appeal, that isn't quite what the Court of Appeal was doing. They cite paragraph 9 and 10 of the Court of Appeal as the only support for that assertion about common ground, So if we could go there, and he did, to be fair, take you there. And that's at page 739. I believe.
189?
Are you Court of Appeal?
189.
189.
189. Yes, sorry, that it, 739 and 743 are the two places in their printed case where they repeat that assertion about common ground. It's at 189, paragraphs 9 and 10. Thank you very much. I'm sorry about that mistake. I had actually made a note to myself of where the assertion was and then misled myself from my notes. 189. And the two paragraphs they cite are 9 and 10. So I ask you to just briefly look at 9 and 10, because again, this is just being fair to the Court of Appeal. CDC and the Attorney General, together the appellants, assert that the disputed land being swampland covered by water is part of the foreshore, and they rely on the common law presumption that the foreshore is vested in the Crown. The presumption set out in Halsbury's, and they quote Halsbury's. The appellants support this presumption by reference to the evidence that the disputed land is swampland and is almost entirely covered by seawater. Therefore, it is part of the foreshore and belongs to the Crown. Further, there is no evidence that the Crown disposed of any part of the disputed land or any other person. No credible evidence acquired a possessory title to the land. The presumption therefore operates. So, in 9, what the court is doing is it's reciting in obviously abbreviated form what CDC and the government were saying. That's what it's doing. It's trying to summarize how they put the position. And then at 10, it says, if the fact that the disputed land is swampland covered by seawater is sufficient to invoke the presumption of Crown ownership, the appellant would be on good ground because the evidence of water coverage is not disputed by the respondents. That is what they seize on. But of course, they're not saying that they'd be on good ground in the sense that they would have succeeded. They're just saying, look, this argument doesn't even get off the ground as it were. They would have had a ground to stand on if the fact that the disputed land is swampland covered by seawater is sufficient to invoke the presumption. They would be on good ground. They could have had a basis for what they were arguing. And they don't say, because the evidence of seawater coverage is not disputed. All it says is the evidence of water coverage. They don't say the extent of all the water, all the land is covered, or that almost all of the land is covered in seawater. Yes, the evidence of water coverage is not disputed. Everybody accepts that this is swampland. Everybody accepts there is water on the land. Let's see what the evidence therefore really said. And my learned friend took you to some of it, and it's fortunately very brief, so I'll take you back. And the only thing he referred to that I am not going to give you the references to is he talked about Mr. Alain, who was the surveyor for the Corions. He said something about water and land, but all Mr. Alain said is it's swamplands. That's what Mr. Alain said, swamplands. But apart from that, what was said is if you go to page 308, you get the cross-examination of Rondell Lendor. He was a neighbor. You go to line 10. As my lords and my lady have it, line 10. Question. So he's being cross-examined. And he says, okay, that is to say, being cross-examined either by, he's being cross-examined by counsel for CDC. Question. Okay, and in relation to your reference, the land is a swamp. Would it be correct for me to say that this is because the land is largely on the water? On, whether it was...
I think it's probably underwater.
Yeah, well, in water, under, we don't know, but whatever. But the answer, the land tends to be more underwater at a certain time of the season. So more often than not, it tends to be underwater. So, yes, I mean, the answer they got in cross-examination, albeit it wasn't focusing on this, is that at a certain season, the land tends to be more underwater. But that is not consistent with this being seawater. It's much more consistent because, again, I don't want to give evidence from the bar table, but in our part of the world, we have two seasons, wet and dry season. It's a sort of quasi-monsoon, if you like, type of climate. So in the rainy season, the land, and that is not pressed. Nothing more is made of that. But if that's the first piece of evidence that the land, as it were, is either to some extent swampy, underwater. Much more consistent with the source of that water being seasonal rain and runoff from seasonal rain and sea. Then you go to page 283, cross-examination of the first respondent, Margaret Corion, who gave evidence.
I'm so sorry, page number?
283, my lord. And again, she's being cross-examined by counsel for the appellant. Top of the page, line 2. Good. And would it be correct for me to say, Ms. Corion, so it's actually being suggested now to Ms. Corion, would it be correct for me to say, Ms. Corion, that in relation to the disputed property, the majority, if not all of it, is covered from time to time by water? So that's a suggestion that's being put to the witness by counsel for the appellant. And the answer, during the rainy season. So perhaps I wasn't giving evidence from the bar table, as it were. Completely consistent. Again, far more consistent with the idea that you have accumulations of fresh water during the rainy season that may flow onto this land and create these swampy conditions, and the idea that this is somehow common ground, that the entirety or almost the entirety of the land is under seawater.
And these questions and answers were put and given before the issue of the foreshore was raised.
Before it was raised. And then at 288, to be fair, the other passage that my learned friend did reply upon in the cross-examination of Corion, 288. So for completeness, maybe we should just go back there.
This is Margaret Corion still.
Cross-examination of Corion at 288, line 15. Yes, now I want to ask you, Ms. Corion, is there any part of the disputed property that the seawater comes into? Answer, into the carronage where the boat dock, there's a circle there. Question, there's a circle of the disputed property. Answer, the way the land is situated is an area for docking boats. And then she says, I'm asking simple questions for simple answers. Well, I'm not sure about that, but but the point is,
dock a boat in a swamp.
Oh, yeah.
If you haven't got a, well, I defer to Lord Bates.
the only sense
That's where you put them when there's a hurricane.
The only sense I can make of it is there's an area in the disputed lands, and you could imagine there might be that you could get, it's on the coast, so you may get, I don't know if you call it a bay, a cove, a circle, that she talks there is, and she talks about being the carronage. Now again, I'll give evidence from the bar table if I might. I mean, in our part of the world, I don't know if my lords are familiar, but we have these things, some islands call them carronage, some call them careenage. And it's because you careen the boat. And careen means to turn a boat onto its side. It's we careen a boat. It's actually in the dictionary. And therefore the place where you careen a boat is a carronage or careenage. And you do that back in the day because, of course, barnacles and so on would accumulate. And so you do one side at a time, and you clean the barnacles. And the place where people traditionally bring boats to careen them became careenages, became carronages. So there might well be an area where, you know, on the edge of this property where it meets the sea, you dock the boat, and the seawater comes in that area, just like it would on any parcel of land that adjoins the sea. Who knows? But certainly it can't be that it's evidence that almost all of the 7 acres of this disputed parcel is continuously under seawater. And that is not common ground. The closest there is to anything like that, of course, can't be common ground because it's the evidence, again, we learned in front of you two, of Dennis Thomas at page 351. But Dennis Thomas was this appellant CDC's witness. So he wasn't in a position to make this common ground. He was their witness, and in cross-examination at 351, at line 9, he's asked, what we would like to know is, could you tell us how much of the disputed land is covered by water based on your knowledge of the area? And he answer, by water, 90% up to 100. But again, when, how often, how long, what kind of water, where does the water come from? None of that. And again, based on the other evidence, it's seasonal, it's rainy season, it's fresh, therefore. And the only area in which seawater does come on the land is this one area where there's a circle where the boats are moored. So how do you get common ground that almost all of the disputed land is under seawater, so that you get into this highly exceptional situation in which you have triggered the presumption by saying, even without showing where the line where the foreshore begins and ends has been shown, and therefore I can show I'm on the seaward side, you must presume I'm on the seaward side, because it's so obviously the case, because this is like an offshore fishery of some sort where, you know, no one's going to ask for that line to be examined. If you could just give me a moment. Sorry, my lord, unless there's anything further apart from the fact that Millennium Jr. is going to give a reference that was asked for that I don't have.
We'll have the reference in due course.
Well, I have a reference now. This is in reference to
Mr. Thomas's supposed admission, which is accepted not to be an admission.
Yes, so I think best just to read from page 340, line 10.
340, line 10.
340, line 10, through to 344, line 11. That covers both.
Thank you. Thank you, Mr. Pennington-Benton.
Yes, so my lords, unless I can assist you further,
Thank
you very much.
Thank you, Mr. Henderson. Mr. McGee.
Lord, can I respond to some of those points? Only some of them very, very briefly. Perhaps I can turn first to the foreshore seabed point. One or two points of law and then a point on the fact. Firstly, the extent of the land to which the foreshore seabed presumption applies can vary over time. And it will vary over time if the high water mark changes over time. So, for example, if it were the case, simply by way of example, but if it were the case that in 1914 the land was not seabed or foreshore, but it became seabed and foreshore thereafter, so that the high water mark moved, then it would become Crown land.
Would that be so even if it had previously been in the possession of...
Well, subject to adverse possession, of course. Subject to a claim for adverse possession, but putting aside the question of adverse possession and looking at the question of title, that would be so.
So you say the Crown could gain title by the encroachment of the sea?
Indeed, it can gain title and it can lose title. There's a reference to the authorities to that. We haven't taken you to a much more modern case of Luce and Lynn shellfish.
Yes.
It's paragraph 77 of that judgment, and it's page 1001 in the bundle. So it's not fixed at any one point in time. There'd be no reason to fix it in 1914 as opposed to 1885 or any time at all.
So the erosion of the east coast of this country is resulting in the Crown acquiring title to the foreshore between a mean high water mark and mean low water mark, unless it's in the possessory right of somebody else.
And indeed, the converse can be true as well.
And we see that in Luce, do we?
Yeah, we see. Perhaps I should go to that. Page 1001 in the bundle. And it's paragraph 77.
Thank you.
Whether one is concerned with the ownership of or rights over land, the principle that land can increase or indeed decrease as a result of accretion is well established. And then there's a quote from Lord Wilberforce in Southern Centre of Theosophy and State of South Australia. So it's a very well established principle. There's nothing controversial about it.
So if land is not foreshore and it's owned by someone, and I buy that land from them, and then because of erosion, suddenly it becomes foreshore, I just lose title to that land.
Milady, yes. The bit of your back garden that's fallen into the sea becomes owned by the Crown. Similarly, if there is accretion so that your back garden gets longer and longer, the cliff goes further and further away, then that land's no longer owned by the Crown.
Well, who is it owned by?
Well, it will be you. It will be owned by you.
No, I can't do.
But this is very interesting, but I'm not clear at the moment what the relevance to this case
Well, the relevance of it, Lord, is at one point in Malone Friend's submissions, he took you to the 1904 plan and said, look, there's the high water mark 1914, there's the sea, therefore we're on the east side of that, the disputed land's on the east side of that, therefore the presumption doesn't apply to it. I say that doesn't matter. The question, we're looking at two different questions.
So you're saying you should be looking at it at the date of the trial, not in 1914?
Lord, yes. Right. So there are two different questions with two different dates. The question of what is the Grand Answer State is a 1914 question, yes. Whereas the question of what is seabed or foreshore is a date of trial question. And we do know, because there's a reference to it in the evidence, that there was apparently a huge storm in the 1930s, and as a result of that, the lendors had to retreat eastwards. For example, I won't go to it, it's page 511, paragraph...
There's a reference to it in some of the evidence we've just been shown.
Yes. So, so that may be the case. That's the first point I wanted to make. The second was about the case of Attorney General Emerson that Malone Friend took you to, yes. And the reference to presumed title. Yes. It's a curious notion. The answer, I think, is this.
It's presumed Crown grant.
Well, yeah, it's obviously presumed Crown grant. What I think it is, although we need a little further research, is it's a reference to adverse possession. We know that if we were talking about easements, not possession of land, that there is a notion of presumed lost grant. If you exercise a right of way for 20 years, then it is presumed, an irrebuttable presumption as it happens,
lost modern grant.
Of lost modern grant. And in my submission, this is the idea that's being referred to here, that if you're in possession of land for a sufficient period of time, it's presumed that there must have been a grant to you of that land by the Crown, if it's foreshore or seabed, and that's what's being referred to. But
that's contradictory then to the two cases, the Ocean Estates and Pindar, and the Sigma Marina and Redhead cases, which I thought you relied on to show that because CDC has the license from the Crown, they're not required to show that the Crown actually owned the land. They can just show their paper title and no one can query what's gone before. But as regards the presumption of foreshore, you seem to be saying even if it's in the 1885 conveyance, that's you do have to go behind that. So is there a different rule then for the foreshore presumption from the rule that you seem to be relying on to the opposite effect in the ocean states in the Sigma case?
Lady, no, there are two completely different ideas.
Yes.
The first comes from the idea of relative title at common law. So if one is in possession of land, one has title to that land unless someone else comes along showing a better right to that land. So if Malone Jr. Mr. Strang is in possession of a bit of land, he is the owner unless I can come along and show that I have a better title, notwithstanding that there may be someone else who might have a better title still. That's the idea of relative title, and that's why possession is the starting point. If you have possession, you have title, you succeed, unless someone else can show a better right. The idea of adverse possession is something completely different, which is that if...
No, I understand that distinction, but I thought that the point of those cases was that the person who has paper title by which they try to defeat the adverse possession well, someone who is claiming adverse possession and is met by someone saying, no, I have not agreed to you occupying the land for 20 years or whatever, I have the title against you, which you are claiming to adversely possess the land. How do they establish their paper title relative, which then has to compete relative to the adverse possession?
So there is no way of defeating a claim to adverse possession. If you show you've been in adverse possession for the requisite period, then paper title cannot defeat that.
No, so, I realise that. What I'm saying is, who is it who puts the person claiming adverse possession to prove that they have occupied it for 20 years? The person who has the paper title to the land?
Maybe the person who has the paper title, or the person who is in possession of it for the moment. Someone was in possession of it for the requisite period and then goes off the land. Somebody else comes on, then that person's in possession for that moment in time. But the first person comes along and says, oh, but until you came onto the land last week, I had title by adverse possession because I had it for the previous 20-odd years. So in the present case, to take a more particular example, although the Crown was in possession from May 2013 up to the date of the trial through CDC, it's open to Malone and Friends clients to say, but we were in possession immediately before that. We were in possession for the requisite period. And if that's so, they would succeed, which is why we say if we're right on this appeal, the question of Malone and Friends is entitled to ask the question of adverse possession to go back to be decided by the trial judge. So lady, I'm not sure if that assists, but I'm doing my best. So that's what I want to say about Attorney General and Emerson. And the third point on it was this. It needs to be part of Malone and Friends' case that the seabed and foreshore presumption doesn't apply to any part of the disputed land. Because if it applies to any part of the disputed land, then he's not entitled to a declaration that the whole of the disputed land belongs to the estate. It's a small, obvious point. The final thing I wanted to say about the foreshore and seabed presumption is this: I won't go back.
The point you've just made, is that the first time in these proceedings that point has been made?
I think it may be the first time we said it today. I think we do say it.
No, I meant before. Has it been made before?
Well, Lord, I think we do make the point in our written case. Yes.
I see.
Yes, it's in our notice of appeal.
Right.
But nobody so far has sought to divide up disputed land into different sections.
But it goes back to my fundamental point. We were in possession at the date of the proceedings were commenced. The onus is on my learned friend's clients to establish title. He accepts the burden of proof was on him. We say it goes rather further than that because we were actually in possession as well. So therefore title is ours unless he can prove the contrary. And in order to get the declaration that it's being sought by the estate, they need to prove that the 1914 conveyance conveys every part of the disputed land, and that we say that the foreshore and seabed presumption doesn't apply to any part of the disputed land. Failing which, the matter needs to be remitted back to the judge to make the appropriate findings. The final point, I won't go back to it because you've been taken, I think, twice now to the passage in the Court of Appeal judgment in relation to saying that it was covered by seawater. This is paragraph 9 in particular, paragraph 10, and you were taken by me and by my learned friend this afternoon again to more of the evidence on that. We say that on a fair reading of that evidence, there was more than enough for the Court of Appeal to come to that conclusion. And therefore to come to the conclusion, but for the reasons that they rejected it, that the seabed and foreshore presumption applied. That's what they said. And they said, we would have said that the seabed and foreshore presumption applied, but for two things, neither of which are now pursued. One is that as a matter of law to establish the foreshore and seabed presumption, you need to provide evidence of the high water mark. That is a point that is no longer put, but seems to be the way that it was put by the Court of Appeal.
Isn't it? I thought it was still put.
Well, no, I think what my learned friend says is on the facts of this particular case, because the matter is in doubt.
Well, no, he conceded that if what you're talking about is an isolated piece of water 100 feet deep, 10 miles offshore, you probably haven't got to show where the mean high water mark is.
Yes.
But that's a fairly small concession in the context of the facts of this case.
Well, the way the Court of Appeal appeared to put it was that as a matter of law, you can only establish the high water, you can only establish the application of the seabed and foreshore presumption if you provide technical evidence of the high water mark. We say that is not so. Neither the other ground for rejecting that was one of their grounds for rejecting the application of presumption. Their other ground for rejecting the application of presumption was the Crown Lands Act, which is no longer pursued. That's all I want to say about that. Can I say just a couple of things, if time allows, on the 1980 plan and the 1904 plan? And can I go back to the very last time, to the 1980 plan? And we know, and I think my Lord Richards pointed this out earlier, that it's said to amount to a grand total of 163 acres. We see that in the words at the bottom. The other thing perhaps I didn't sufficiently emphasize is that this is, again, looking at the words below the plan, this is supposedly a plan of the Grand Aunt's estate being the property of the late Samuel Corion. So this purports to be the Grand Aunt's estate as it was owned by Samuel Corion before he died. And he died in 1921, 7 years after the 1914 conveyance. And no evidence of any other conveyances of land to him between 1914 and 1921. We know in 1914 that he was purportedly conveyed 106.5 acres. Suddenly this is 163 acres. So the idea that the estate is larger is a much more recent proposition than 1914. That's the point I wanted to make about that. The learned friend says, oh, well, Mr. Thomas, look at his evidence. He's a surveyor. He's used his professional judgment. He did this plan. He wasn't just drawing a sketch for Mr. Corion. My learned friend admits that it was done on the instructions of Mr. Roosevelt Corion, and it was done without a survey on the basis of boundaries as pointed out by Mr. Corion. My learned friend says, but he's a land surveyor. He would have used his professional judgment to know where the boundary was. And Lord, my answer to that is simply this. One wouldn't expect Mr. Thomas to have inquired into the deeds. One wouldn't have expected Mr. Thomas to inquire as to whether there was sufficient evidence to establish title by adverse possession. He was simply drawing the boundaries as pointed out by Roosevelt Corion. It's got no further significance than that.
Well, we're looking at this 1980 plan.
Yes, indeed.
I see. I mean, it says, doesn't it, plan of Grand Annecy Estate being the property of the late Samuel Corion, and it's signed by Mr. Thomas.
Yeah.
But you say he's not taking any responsibility for that.
No, I do. If your lordships go, I don't think we've gone to this. 492. This is his witness statement. My learned friend went to a number of paragraphs in the witness statement. I don't think he went to this one. This is paragraph 6.
Bear with us, please. Page 492.
Page 492, my lord.
This is the witness statement of
Mr. Thomas.
Where you say that's what he says in terms.
Yes,
Yeah.
he says that in terms. In paragraph 6.
Paragraph 6. The request carried out.
the former employer being
a foreign employee of the firm that you see in the previous paragraph.
He says the request of my former employer.
Yes, that is of the firm Keynes, Douglas and Partners.
I see. And the instructions were given by?
They were given by Mr. Roosevelt Corion, the grandson.
Roosevelt Corion, that's what I was thinking.
Yeah.
Thank you very much.
So far as the 1904 plan is concerned, if finally I can go back to that, a couple of interesting things to note. The swamp plan at the top left, its common ground is owned by the Crown. Loanfed, I think, suggested at some point that there may be a conveyance to the Crown, but we've seen no reference to that whatsoever.
Sorry, the common ground that was owned then by the Crown?
Well, it's owned, we know it's owned now by the Crown.
Well, as I understood it, what was being said was that this was part of the reserved part of the Harvey Vale estate, because it's in grey. It's
referred to as reserved. We don't know what reserved means, although I think I rather agree with my learned friend. It means it just wasn't subject of the lots. There are numbered lots, and the grey areas are reserved in the sense of being not subject to lots. We know that the swampland is owned by the Crown. Now.
Yeah.
There is no evidence that the Crown acquired it by way of grant or conveyance. We see that the western boundary...
Isn't that also foreshore?
Yes, indeed.
Sorry, I'm a bit lost with this.
That's precisely my point. The swamp is also part of the foreshore.
Maybe the Crown got it by accretion during some storm or other.
Well, no. What we're saying is the position nowadays, at least, is that is Crown land. I can't say what the position was in 1914, but we know of no conveyance. So we know that is Crown land now. We're talking about the area immediately to the north of that. Why, I asked rhetorically, should it be in different ownership?
Why should what?
Why should it be in different ownership?
Well, because the Crown sold it to somebody.
I mean, the 1904 plan shows it as forming part of the Harvey Vale estate.
Yes.
Yes, not owned by the Crown.
Well, it doesn't say who owns the Harvey Vale estate.
Yeah, all right. So you're saying this... are you saying the Crown did own the Harvey Vale estate?
Lord, we don't know who owned the Harvey Vale estate in 1904. All we know is that whoever owned the Harvey Vale estate in 1904, now that land is part of the Crown.
Well, we don't know that. All we know is that the claimants are not claiming it as part of their estate.
Yeah, and nobody else has claimed it.
Nobody else has claimed it.
Yes.
That's what we know.
So we're talking about the swamp,
yes,
which is shown in grey.
Yes.
On the 1980 plan, drawn up by Mr. Thomas, shows a boundary there with the government of Grenada written below it.
Yes, although we also know not in precisely the same position for what it matters according to Mr. Masaki.
Is that material for present purposes?
It may not be, my Lord. No.
But I mean, they presumably write that there because it was by then vested in the Crown. Legal title was vested in the Crown. I mean, they wouldn't write government of Grenada because it was forcial.
Yeah. The concern at that stage, I
really don't quite see what your point is. I mean, because in 1904, whoever owns this, the grey shaded swamp is part of the Harvey Vale estate, not part of forcial, part of the Harvey Vale estate.
Yes.
So what is your point?
Well, my point, my Lord, is a very short, simple point, is this, that the nature of the land, of the swampland, is similar to the nature of the land to the north of it. The land to the south is owned by the Crown. Nobody is disputing that.
But it is owned now by the Crown?
Yes.
But not necessarily in 1904?
Well, but if the Crown has acquired it, there's no evidence it's acquired it by a conveyance.
Well, there's no evidence of this at all. I mean, no one's put in any evidence. I mean, isn't the presumption is that it did acquire it by conveyance? It's shown here not as foreshore, but as part of the estate.
Well, either that, or it was recognised at some time that it was part of seabed and foreshore.
It's just speculation.
Yes, but Lord, I entirely accept.
In reply.
Yeah, Lord, I entirely accept it's speculation, but the speculation assists me, not my learned friend, since the burden is on
you say
him.
yes, the burden's on them. Let speculation thrive.
Indeed. Well, that's the way I put it, rightly or not.
Well, which of the other boundaries do you also? I mean, do you then say, well, why would the Endeavour estate? Why would they own that land? Why isn't that also part of the Harvey Vale estate? I mean, there are boundaries between land owned by different people. You say that there's something about the nature of swampland that means that a whole swamp is likely to be owned by the same person rather than divided between two owners.
No, what I say is that the nature of swampland is it's adjoining the sea. And therefore the nature of swampland is it's not land that's suitable for cultivation or for building on, and to which the presumption, the seabed and foreshore presumption, has at least the potential of applying.
It doesn't necessarily adjoin the sea. It may adjoin a large stretch of sand over which the tide never goes.
Well, in theory that might be possible, but doesn't look as if that's the case here, my Lord.
But I thought coastal land was very valuable in places like this because you can build a marina on it.
Yeah, well, it certainly is now, my lady, yes. I suspect or we wouldn't be here. Yes. Lord, two further short points by way. I'm sorry, I'm trespassing on your lordship's, your ladyship's time. The one was about Mr. Masaki's evidence, and some emphasis was put on his production of the 1904 plan, and as to what he says about the boundary with the Grand Aunt's estate. In my submission on analysis, all Mr. Masaki was doing was producing and seeking to interpret the 1904 plan. It goes not one jot further than anything one might say about the status and purpose of that plan. And the final point was this. The learned friend said a little about the other evidence beyond the plans. The other evidence was confined to two sorts. Firstly, from Mr. Corion, and secondly, from Mr. Lendor. Mr. Corion was born in 1948. Mr. Lendor was born in 1950. A long way away from 1914, and neither of them was, in my respectful submission, able to say anything useful on the extent of the Grand Anse estate in 1940. Well, unless I can assist further, that's all I wanted to say in reply.
Thank you, Mr. McGee. I don't think there's anything else for you. We're very grateful to you, Mr. McGee, and to Mr. Hamel-Smith for your submissions today. We're also very grateful to those sitting alongside you and behind you, who've no doubt done a huge amount of work for the preparation of this hearing. We are grateful to you all. The board will take time to consider what advice we will humbly tender to His Majesty in due course. Thank you very much.